Good morning, everyone, and thank you for joining us today. I'm going to just type in quickly, can you hear me, to make sure that everybody can hear me. If you just want to type back and verify whether you can go to your chat button, which is at the top of the screen, and let me know. But we're going to go ahead and get started. And I'd like to start by just touching a little bit of base about who I am and what my perspective is. So it's a little bit different when you are going to a workshop for compliance management for medical leaves and accommodations when you're dealing with an HR consultant and an attorney. And so this will be a little bit different than maybe other workshops that you've been to. My focus and my intent today is to make sure that you are getting an overview of how this works in the trenches when you're doing the work today and tomorrow and next week. Real time, as opposed to what case just closed and what did the results of the case say. So let me tell you a little bit about who I am and what my perspective is going to be. We're going to talk today specifically about the issues related to accommodation and leave, not only from the perspective of when those regulations run together, but when you have workers' comp, if you're in a state that has workers' comp, or you've got issues with performance management, or you've got issues with complaints about retaliation and harassment. And if you've been doing this for a while, you know that these things all can run together quite quickly. And we've got employees that are really motivated to start an investigation or complain about harassment or discrimination because they are potentially being impacted by performance. And they've heard the scuttlebutt that if you've got a leave or an accommodation, you can stop the process. So your employees are getting more educated. So that's what today is about, is really how do you handle this stuff when you're in the trenches and you are trying to prevent litigation, not do you have to go to an attorney to call for some help. So your questions and feedback are really important to me. If you chat me something, I will integrate it into the workshop as appropriate, or I'll just answer your question explicitly. So let's talk a little bit about who I am. And I am an HR consultant. I've been doing this for about 25 years. So I started working with FMLA and ADA when they passed. And when I was getting my master's degree, which was an MBA, one of the gentlemen that I was being taught by, a professor in Sacramento, was one of the primary individuals who created the seminal documents for the firefighters in terms of an essential function job description. So female firefighters could then be tested to verify if they could actually participate in the job and perform the essential functions at a physical level that's required for a dead carry, and managing that very, very powerful hose. Those are some of the rationales why women couldn't be firefighters. And 25 years ago, these are the things that are 26, 27, 28 years ago, these are the things that we were looking at. And so I started getting exposure to this during my master's degree. And immediately after I graduated, I started working as a vocational consultant, handling not only expert witness for the federal government for Social Security disability hearings for people who are injured on workers' comp and then want to get Social Security disability. When they don't get the federal Social Security disability, they often sue you under ADA and FEMLA because they're running out of money and they can't come back to work. And so that would be a position that I would take as an expert in that federal hearing, describing why that employee can or cannot do any job in the national economy, by the way, without accommodation. So it's a lower standard, but it's still very, very difficult to get. So I've been doing that for that long also. And what we discovered then in some organizations and in some states is that you've got challenges not only with workers' comp, if you're a state-specific area that has it, but also your union contracts may impact how you manage these leaves and accommodations in the workplace. So what we're trying to do is give you a holistic perspective, not only from what did the cases say, because I actually do expert testimony then on wrongful termination cases and harassment and discrimination for both the plaintiff, your employee, or for you, your expert if your litigating attorney calls me. So what happens in the anatomy of litigation is that your employee gets fired or demoted or suspended or in some other way impacted, and they believe it's retaliation, which is, I think, about 43% of all EEOC claims now include retaliation clauses. They consider it retaliation. You get named on the lawsuit, by the way, because you're the one who made the decision to terminate them. Don't we love our job in HR? And then the next step is who's suing whom. And if the employee is suing you, their attorney may call me to provide an expert opinion about whether HR managed the process correctly under HR standards, or your attorney might. Now, your attorney is usually not your attorney. Whatever your attorney is for your corporation, if you are insured, is going to be the attorney who lets the insurance company know, and then the insurance company is going to be hiring a litigator. And it's that litigator who will call me. And very often you will never be informed about any of this. And that's where the challenge comes in, is when even you are sued yourself as an organization, you may never get feedback from the attorney, the litigating attorney, about what you could do to fix this so it doesn't happen again. We're going to talk about the things that impact you real time when you're doing these regulations and you're trying to get this done today that can help you prevent this, retaliation claims and harassment, discrimination, and those kinds of related wrongful termination claims from the perspective of implementing it in your workplace. So I'm not an attorney and I'm not providing legal advice. And remember that you guys aren't either. So when you are doing harassment, discrimination, and retaliation investigations, you are never trying to determine whether a law was violated. You're also always trying to determine, is there a policy that was violated? So someone could violate the law, but that's not the determination you're making. It could be a very, very, very lower standard for them to violate a code of conduct policy or harassment or discrimination policy that would never reach the levels of litigation or violating harassment discrimination at the EEOC level as a law, or an FMLA law, or an ADA law. So we're going to talk about how to maintain the integrity of what you're doing every day. So if there is an employee who feels that you did violate the law in some way, you've got the documentation to show them you did it right. So we're covering a lot in an hour and a half, but I want to make sure that you feel comfortable and confident to go ahead and chat me if you've got questions, because this workshop is really helping you understand what you don't know so you can get additional help if you need it. So first of all, let's talk about this litigation and what it costs your organization in general if these regulations are not managed correctly. Well, we know there's been a 430% increase, everybody, in employment litigation in the last 20 years. That's an average of 100,000 filings a year at the EEOC in the last 4 to 6 years. And workers' comp attorneys are getting involved because they can't sue you under workers' comp as easily anymore. Or they are learning the strategies under FMLA and ADA on top of workers' comp. We've got an 85% of all EEOC claims are existing employees. And if you remember correctly, if you've been doing this long enough, the ADA was not passed for existing employees. It was passed to help people who were disabled get to work, not stay at work. And what we're really finding is that we are applying the ADA to very transitional and temporary conditions following FMLA because we have to. And the ADA has said we better. And we need to stop looking at whether it's a disability and see how we can accommodate. So the implementation and the spirit of the regulation has changed tremendously since the last 25 years when we originally passed this. And then we've got this increase from $5 million to $50 million in 1 year for the same amount of claims from the EEOC. That's a $45 million increase. So the EEOC is getting extremely aggressive with organizations. That means the EEOC sued an organization about this. You've got the cost of litigation, which is an average of $200,000 to $500,000 per case prior to litigation. Your company has that. If you've got insurance, you're probably paying $25,000 to $100,000 deductible before you even get to it covered under these kinds of lawsuits. And there are a lot of indemnifiers in there. So make sure that you are really clear that you understand the loopholes to your insurance. Absenteeism and healthcare costs. We absolutely know that one of your biggest costs is ongoing medical expenses for people who have exhausted FMLA that you haven't cut their healthcare off yet. So we're going to talk about making sure that you're paying attention to that. What about just being gone from work and productivity and morale? Well, we can't talk about what's going on with an employee's medical condition in the workplace at any time ever. We can't even talk to the supervisor about it under ADA, and certainly under FMLA, you should not be talking to supervisors. Supervisors can't talk to their employees about their medical condition under any circumstances ever. So if an employee talks to them, they got to come to you. Your supervisors care about one thing. There's a body in the chair that is getting the job done. That's their responsibility, so they can meet their productivity requirements, whatever they be. Our job is to make sure there's somebody in there. So let's make sure we are managing these leaves, and it is not the supervisor who is telling us when they don't come back. We already know they're not coming back because we called them 2 days before they were supposed to. These are the kinds of things that cost your company money. The sooner you can get involved in managing the monetary aspects of these leaves to minimize that for your corporation, you are now becoming a member of the management team. And HR is striving for that role because we are treated as glorified administrative assistants. To be treated as professionals, we need to start keeping matrix ties. And this is one of the ones that you can keep track of really quickly, because if you're designating FEMLA within 5 days, which is the regulation, by the way, and you can't retroactively designate without impacting the employee if you retroactively designate and cut their health care off early. But if you designate on time, that means you're cutting their health care off the first day of the month following the month in which the FEMLA leave exhausts. ADA doesn't protect health care. And there are a few other regulations that do, depending on your state. So please be sure that you are on top of that so you can start keeping track of how much money you're saving your company. The methodology that I have implemented and I have designed over the 25 plus years I've been doing this in the workplace with HR consultants from the beginning is a system that incorporates compliance, integration, communication, follow-up, performance management, and consistency. So every piece of this matters. And if you use a third-party administrator, they are not integrating for you. They are simply the water boy. And I mean that seriously, because your job is to make sure that water is clean, that the way they bring it is following all of your policies and procedures, that they are not making the final decision to keep the water empty. In other words, they don't ever get to make the decision to terminate an employee. You do. So if you have a third-party administrator who is not complying with all your other employee policies and procedures, not complying with the ADA, and you're using them for FEMLA, your responsibility is to make sure you take that case over 2 weeks before FEMLA is about to expire and make sure that, first of all, that employee has absolutely received all those letters. And if there's no confirmed delivery or FedEx or certified mail, we're sending them all over again, folks. And that would be you, not the third-party administrator. So you are in charge because you'll be on the lawsuit if there's a termination, and very likely they will not be. So integration with all your policies and the employee life cycle process from recruiting to termination. Communication is the most important thing. Are you making sure they're getting the letters? Are they confirmed delivery? Are they certified mail? How are you speaking to the employee when they let you know they need a leave or accommodation? Are you training your managers so they don't speak to the employees about accommodation and leave? How are you training your managers in terms of communicating with your employee as it relates to complaints of harassment, discrimination, or failure to accommodate or provide FEMLA leave in the middle of a performance management that's going to end in suspension or termination? Are they being trained to continue that performance management meeting and acknowledge the complaint and take the employee to HR immediately following the meeting? Are they being trained to end the meeting if they are the subject of the complaint and bring it right to HR? And then how are you following that up? What is the follow-up with all of your communications? What's the follow-up for the leave ending, for the ADA beginning, for the healthcare ending, for PTO ending, for vacation ending, for sick leave ending, for STD ending or LTD ending, for workers' comp ending? And when are they supposed to come back? Please remember that all of this is your job, and failure to do this is what we see causes litigation. Not only from the perspective of your employees feel out of touch, and we can't call them and ask them about how they're feeling because we're engaging in a medical discussion now, but we sure can call them and say, hey, we're thinking of you, just wanted to check to see, are you coming back in 2 days? Or do you plan on extending your leave? If you do, by the way, we sent you that letter that tells us you have to get us that medical certificate tomorrow. That's the kind of communication I'm talking about. Inviting them to the Thanksgiving party and giving them a coupon for the turkey, making sure they get the newsletter. Are you allowing them to continue to work and look at their email? Are you allowing them to access their phone when they're on a unpaid FMLA leave? We don't do that even if they're on a paid leave because they're getting sick in vacation. Communication and follow-up is key in this area. Using a third-party administrator does not eliminate your responsibility to do that and know exactly what's going on at all times with that client, with the third-party administrator. Most of your third-party administrators will not deal with ADA, and even if they do, it is notification only. A third-party administrator does not have the skill level in most cases to understand the depth of knowledge, case by case, location by location, job by job, site by site, commute by commute, job description by job description for that particular time frame that employee works. That's what ADA requires. Performance management, that's the other issue. Are you really applying your performance management system correctly when you accommodate? Because performance is the key to a qualified individual with a disability. They are not a qualified individual with a disability if they cannot perform the essential functions of the job with the accommodation. So you need to monitor performance. But when performance is impacted by accommodation, you are not terminating, you're re-engaging in the interactive process to find another accommodation, because performance management is just an indicator of not QID, not an indicator they're getting terminated. And it's ADA requires you and expects you to go through this process over and over and over again if the first accommodation doesn't work, including saying it's not going to be able to accommodate you under your usual job because you are not a qualified individual with a disability under your usual job because you cannot perform the essential functions of the job when we accommodate you with leave or telecommuting or voice-activated software or a lifting piece of equipment. So therefore, we are now going to look at every other job you minimally meet the expectations, the qualifications for, and we can try accommodating in that job. Very different application for performance management. And then consistency. Are you really applying all these regulations and policies consistently? Does every person who walks out your door who's gone for 2 weeks required to provide a return to work release? Every person for their own medical condition. For every policy, for every situation at all times, if it's their own medical condition. If you're not doing that, you're not consistently applying the return to work release and the physical ability assessment. That's what we're talking about. So beware, when FEMLA and ADA and workers' comp all impact your organizations at the same time, how do you manage this? How do you convince management that there is something that they really need to be paying attention to in the comprehensive management of leaves? Any reason they can walk out your door, leaves as it relates to their own medical condition, leaves as it relates to a family member's medical condition, accommodation issues, and the performance management process and the investigation process as it relates to these protected employees, and of course the RIF process too for that matter. If your supervisors and your management team are not allowing you to implement the tools you need to manage this holistically, there's a challenge for you. Keep in mind, you will be named on that lawsuit potentially, as will the supervisor. Your manager may be also if they are the one who actually makes the decision to terminate. But if your name's on that termination letter, please be aware you're probably going to be named on the lawsuit. The other thing I want to make sure that you know about is that HR specialties, this one particular, medical leave management and accommodation specialist in HR, is the fastest growing area of specialties in HR nationally, from the Census Bureau, the Department of Labor, and the local unemployment bureaus. We know this. So you're going to have plenty of opportunities to find somebody another job if your management team is not supporting you. And I'll get off my soapbox, and that's all I'll say about that. Your biggest exposure is always going to come from your non-HR supervisors. So your supervisors in your department right now are not at this meeting. They are the ones who need to know the issue about performance management. They are the ones who need to know the issue about accommodation. They're the ones who need to know the issue about what do you say and what do you do when the employee says they were harassed, discriminated, or it's a hostile work environment and you're about to terminate them. Or they said, well, I've told you about my need for my cancer for my son or my own problem with my hand, and that's the reasons why I'm not getting my job done. And I've told you that 3 times and you're still terminating me. Your supervisor will cause you a lawsuit at that point if they don't understand the strategies to stop the conversation and get that employee to you, or if they are not the target of the complaint, to finish the conversation, but let the employee know they care about what they're saying. It's very important, but it's confidential. They're going to finish this process, and then they're going to take them to HR. And we'll talk a little bit about that in more detail when we get to the second part of the slide set. So these are important to you, for you to remember. We've got a really slick 20-minute training that is just for supervisors to make sure they understand what they can and cannot do to keep from causing lawsuits in your organization. And we typically sell it in bulk to companies, so you can download it from the cloud and designate who has to take it, either as a compliance requirement for counseling because they did it wrong, or we are asking people to do this during the new hire process and onboarding and promotion stage. So supervisors absolutely know about investigation, performance management, criteria for not talking about confidentiality, and when to bring this information to you for a no, you should have known ADA or FMLA compliance requirement. So compliance, what does that mean? That means really understanding all the regulations that may apply to this employee at any time when they take a leave. So it's important to audit your leaves. Take your policy manual home with you, or get on the internet and start printing out all the policies that the reason the employee is grieving is for their own medical condition or for a family member and they're walking out the door. Let's include bone marrow and organ donor, because a lot of your states are starting to pass these regulations too. I can tell you in some states, specifically in California, there are 26 reasons that an employee can walk out your door. What's it like in your state? Know all of them, then read them. How do they say? What do they say? What do they say about medical certificates? What do they say about return to work releases? What do they say about being paid? What do they say about not being paid? What do they say about other regulations that apply concurrently, if not protected by state or federal regulation? That's what we want to do to be consistent and compliant. Don't forget about your company policies, union contracts, and memo of understandings. They all need to be addressed when somebody walks out on leave, and some of these happen concurrently. It is my recommendation that you have all leaves run concurrently unless protected by state or federal regulation. Otherwise, your employees can stack their leaves. And that is never a good idea for your managers and supervisors who are trying to keep a seat in the chair so they can meet the productivity requirements. And heaven help you if you've got a bank of employees that are doing ongoing, as needed, intermittent, is trying to deal with in that situation. We are their advocate in that situation, but we're also the employees. That's our role. We have to walk that line of making sure the employee meets all the expectations of the organization and making sure the organization meets all the expectations of the employee in compliance with state and federal regulations. That's our job. Taking care of FEMLA does not protect you under ADA. It only protects you under FEMLA. So if you are terminating people when they have not returned from FEMLA, expect a lawsuit. I just finished one last week. There was all intention of making this person not a qualified individual with a disability because they were extending their leave over and over again, which you'll hear me say over and over and over again is a legitimate reason to not provide an accommodation, because they're probably not a qualified individual with a disability because they are extending their leave over and over again, and the leave does not provide them an opportunity to return to work and perform the essential functions of the job. But applying that standard without going through the interactive process and having a record having gone through the interactive process for that particular job, and then having crossed over to verify that there is some other job that they can specifically do, is a problem, because you still have no record of the interactive process having gone through that analysis with the employee and given them an opportunity to identify alternative restriction opportunities with an alternative job. If we just send a letter and say, oops, you couldn't return, you said that you could absolutely 100% never work again for this job, what about any other job? Maybe we're okay under FEMLA because it's been exhausted, but we've got to address the ADA, folks. When FEMLA ends, ADA begins every time, all the time, no matter what, until you've determined they are not a qualified individual with a disability or it is an undue hardship to protect them. Inform the employee of your reporting requirements consistently, all the time, in compliance with your regulations and your policies. So if your policy says they have to provide you a new medical certificate, make sure you provide them a letter that gives them a 15-day notice that they have to provide you a new medical certificate on a specific day. Otherwise, under FEMLA, they always get 15 days to get you that medical certificate from the date you sent them the letter requesting it. So these are some nuances that some attorneys don't even know about yet, but they will come up and bite you eventually because they're still learning every year about these nuances. And then make sure your employee knows that they have to bring that medical certificate in when you call and talk to them, so they don't show up 2 days later with a medical certificate saying they need another 3 months of leave when they should have come back 2 days ago. Inform the employee of the reporting requirements, if there's a return to work leave, how you calculate leave. Is it roll back? Is it roll forward? Or is it annual? Do you know? If it is roll back, I highly suggest you switch to roll forward. It will change your life because you will not be spending every day looking at whether they have more leave when you roll back because they're using ongoing as needed intermittent leave. That reason by itself is the only reason I need to switch to roll forward. And the rationale that you are going to end up giving them more leave is just not happening, folks. They're getting more leave because we're not being able to send the letters out because it's so time consuming to roll back and figure out how much leave they have left. So as a practitioner in the trenches with you, it is probably an attorney who made this suggestion. They're not trying to do what you're doing. Get it changed. If you need help in understanding how to change it, email me and I will send you a free outline of exactly how to do it, okay? Because I learned this 15, 20 years ago that we needed to change it. So I just created a methodology for everybody to learn how to do it because of the organizations I worked with. That's the first thing I got them to do is change the leave to roll forward. So those are compliance issues. Inform the employee in writing if you need to cure a medical certificate. You cannot cure a medical certificate you've never received. So curing under FEMLA is very specific. You get 7 days to cure. They don't cure a medical certificate that they are exceeding. In other words, the medical certificate says they get to take ongoing as needed intermittent leave twice a week, but they're taking Friday, Monday leave. That means they're taking their ongoing as needed intermittent leave every Friday and every Monday. That's a problem. That's a scheduled leave. That's not an intermittent leave. And if they're taking leave after vacation, that's not okay. I'm going to be curing this very specifically. And when I cure this, Jenny, you've got, you're showing us. I don't know if your intention is to have your video shown, but you do. Hi, by the way. So when you're curing an ongoing as needed intermittent leave, you really want to make sure they are not exceeding the days on the certificate. As soon as they do, you cure. They get 7 days to respond. They don't respond in 7 days, everybody. They only get 7 more days if they tell you they need it. Otherwise, you get to deny that extra time they're taking. But when FMLA and ADA began, if they don't cure the FMLA certificate, you're going to need to engage in the interactive process under ADA and see if you can protect, or you need to protect that time that they didn't cure the medical certificate under FEMLA under ADA. I guarantee you they're not going to. They're going to cure the medical certificate on FEMLA as soon as you do that. These are strategies, folks. Always make the employee solely responsible at all times, provide ongoing medical certification confirming the need for leave to avoid discrimination and violations of HIPAA. All the time, all the time. Do not doctor call. Do not do it for one who's workers' comp and not for the other. If you doctor call, you got to do it for everybody, folks, so do it for nobody. Always make the employee solely responsible. Define the essential functions of the job and provide this to an employee. I never send a medical certificate request or a job accommodation analysis form unless I also send an essential function job description. Why? Because if I don't send the employee a job description that really is valid and talks about the kinds of accommodations they need because they have a mental condition as opposed to a physical condition and their job is stressful and the job description doesn't even say it's stressful, then I'm going to get nothing back that is valuable. I'm going to get back what the employee decided to tell the doctor, and the doctor said, okay, tell me what to write down, and that's what they wrote down. So the more effective you are in providing the employee a comprehensive, well-designed essential function job description, the more likely you're going to get real valuable information back. And what we do is we create an addendum to the job description that focuses on the functions of the job that the employee can't do, that we haven't described how you get them done either mentally or physically, so the doctor can see the mental and physical requirements of the job that we're trying to accommodate on because the employee has informed us that's their need. Request the employee provide FMLA and ADA specific medical forms. If you currently are using federal forms for FEMLA, that's great. But if they are not getting filled out effectively, there is a design flaw that I discovered a long time ago. So I have changed the format to make sure that they answer all the questions in detail. Keep in mind that the medical certificates are very often being filled out by the front desk medical people, not by the doctors. The doctors are either stamping it or not signing it quickly. So please be careful about assuming the doctor doesn't know what they're doing if it's not filled out. Cure. Let's assume the doctor didn't get enough information and they filled it out poorly because of that. So don't be afraid to cure. The other thing is use an ADA specific certificate. The one that we use on our let's see, on our webpage, I thought I had it brought up, but evidently I don't have it brought up, is, here we go. We've got a certificate that is very specific to ADA. And the ADA certificate that we use is a 6-page certificate that requires the medical provider to analyze. It's not a medical certificate. It's a job description analysis of accommodation with disability. And that's what we're asking the doctor to fill out when we're dealing with ADA. And we've switched from FEMLA to ADA. We want a detailed analysis of, is it a disability, first of all? And stress under FEMLA is not stress under ADA, by the way, everybody. It does not necessarily meet the same standard. It might, but it doesn't necessarily meet it. Stress because I'm getting divorced and I'm upset every day is not the same thing as post-traumatic stress disorder. And you need to make sure that the doctor has enough information about what that looks like so they can provide you the exact details that you need. We will go to the Job Accommodation Network and download the description about what a mental condition is as a disability under ADA and attach that to the letter to the employee so they understand the difference between a FEMLA certificate and an ADA specific medical certificate. Always have the employees sign a medical release if they want you to discuss anything with the doctor. So if they're not successful in filling out the medical certificate, have the employee sign a HIPAA level medical release. And that will say, Beth DeLima has the opportunity to discuss the medical condition of Susan's arm with Dr. Smith for the next 3 weeks. And then I'll get on the phone with the employee, with the doctor, never by itself, by the doctor's by itself, and explain to the doctor how we need to have them fill out this form. I am not going to encourage or request or engage in discussions about medical conditions, even though I've got that release. What my purpose is to help the doctor explain how to fill out the form. And by the way, this is something that we're going to solve. We're going to be creating a training program for medical providers because they don't know how to fill out the forms and they're part of the problem when we're trying to get this done at a compliance level. The supervisor should never, 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 did I say never enough? Contact the doctors under any circumstances. This is confidential medical information. HR can contact the doctor, but only if they have signed that medical release, in my opinion, or only if they are calling to say, can I verify the date? Can I verify what you wrote down? I can't read it. Can I verify this is your signature? That's it, folks. Confirmation only, or you must have a HIPAA medical release. And by the way, anything an employee hands you personally is not protected because they handed it to you personally. They just self-disclosed. But that doesn't mean you get to share it with anybody. So it's need to know only under ADA specifically. And FEMLA, we apply the same standard. And that means nobody needs to know except for first responders, and supervisors need to know restrictions only, not the reason for the restriction. So here is integration. This is the employee life cycle, folks. This is what you do every day when you hire and you performance management and you talent management and you terminate. You've got an opportunity all through this process to manage and comply with these regulations. At the recruitment level, you can have a good essential function job description and ask them to read it and tell you whether they need an accommodation to perform the essential functions. Keep in mind that the little blurb you have on needs.com or Craigslist, or what's the new one? Monster. I know there's Monster, and then there's a brand new one that combines them all. I should know what that is at the top of my head. Is that a paragraph long, or is that the full-blown essential function job description? If it's not the full-blown essential function job description, when does the employee read that and verify they can perform the essential functions of the job? So if you have an employment application that doesn't include a full-blown job description question, or it does, and they say, yes, I've read the job description and I can perform the essential functions, but you know they've only read the one page or paragraph on Craigslist and never seen a full-blown job description. You know they filled it out wrong already. Check your procedure. During the post-offer testing, pre-post-offer testing, post-op or pre-hire, do physical ability assessments on any of your jobs that have high levels of experience factors for on-the-job injuries. Find out if they're qualified to do the functions of the job before you hire them. A physical ability assessment is done by a physical therapist or an occupational doctor, by the way, not by a regular MD under any circumstances. And then it's developed to be job specific. That's why it's important and valuable. Then the doctor or the physical therapist will ask all the questions you can't ask, and they'll provide you a simple report that says, yes, they can, or these are the functions they can't perform. They don't tell you why, they just tell you they can't perform them. That's your key to engage in the interactive process. I've got a really simple example of this where an employer, I did this about 23 years ago, an employer back east refused to hire somebody who was deaf for a position as a forklift operator because they didn't believe they could hear the beep, beep, beep when they were about to run into a wall or a person and they'd cause an accident. Well, after $30,000 of just paid me as an expert, it really only took me 15 or 20 minutes on the Job Accommodation Network, which is axjan.org, by the way. It's a free resource, to find a piece of equipment that went buzz, buzz, buzz by their side, like your phone does when you want to turn it down, so the person could hear that they would potentially in a dangerous situation. They settled that lawsuit and it didn't go to trial. That's the kind of stuff that we are not doing that we really need to be doing. During the new hire onboarding process, are you making them sign off specifically? Not that they read and understand the policy manual, but that you read them the leave accommodation request form. You read them the harassment and discrimination and the complaint procedure and how you do it. That you read them how to complain if they are being harassed, discriminated, or retaliated against. That you went over with them how to ask for an accommodation. And they signed off that they know. Really important stuff, everybody. What about leave management, FEMLA, ADA, workers' comp? Are you managing these leaves, or are you letting the employee manage it for you and the supervisor let you know when there's a problem? If it's coming from the supervisor, you already know that there's a challenge. The supervisor expecting you to manage these leaves, guys, not the other way around. So have a calendaring system, have a tickler system, call people 2 days before leave ends, PTO ends, vacation ends, so their paid leave ends, their FEMLA leave ends, their ADA is about to begin. These are important dates. I would know every day a medical certificate is going to expire, and I'm calling the employee 2 days ahead of time and sending a new letter out well before FEMLA expires to let them know if they want to continue leave protected under ADA. They got 2 weeks to bring me a medical certificate and meet with me in person on this date, which is usually the week that the FEMLA leave expires. We can control medical absences and accommodations when we manage that at that level. The website that I'm showing you down here is my intellectual property on managing leaves and accommodations in the workplace. If you're interested in looking at this, you can go to leavemanagementsolutions.com and go to membership login, and it will show you what resources we have on this page. You can schedule a demo or sign up if you'd like to get more information. That's the reason we designed this web page, is to make sure you have the resources you need if you want to go to the next level of training on this kind of system. Talent management, that's your expertise. How do you do it? Performance management, though, is integrated explicitly into accommodations, and this is so important. You do not implement a performance management system when you accommodate somebody to terminate them because it doesn't work. You implement a performance management when you accommodate somebody to determine the accommodation is not working because they can't perform the job, to document it well enough that if there's a question, you've got objective data to verify you can't, the accommodation is not working and they're not meeting the expectations of the job and not conforming the essential functions that you need them to at a meet expectations level. But as soon as you identify that, you are engaging in the interactive process again, because you got to see if there's another job that they can do it with, or if there's another accommodation that would work with that job. And you're going to do this 2 or 3 times, folks, before you're terminating them because they're not a qualified individual with a disability, because no accommodation of any kind will allow them to return to work, including additional leave, because they keep extending it over and over again. And an ongoing extended leave with no valid return to work date is not going to be a valid accommodation. And they could very well be considered an individual who is not a qualified individual with a disability because the accommodation does not allow them to come back to work and perform the essential functions. A very key issue, but boy, it's got to be done right, or you're going to be spending thousands of dollars trying to prevent this from being litigated in the court of law, which is what I just went through last week with a case that is exactly like that. And they had to go to court to say they did it right. You don't want to have to go to court to say you did it right. Let's get the paperwork done correctly so you can say you did it right. And then the last piece is separation and offboarding, the whole process in general. But if it's related to accommodations that didn't work and you have no record of identifying alternative accommodations, or it's related to an investigation that was not that was complained about and not reevaluated, there's another red flag. In other words, during the performance management process of a non-protected FEMLA or ADA, you may have an employee say, hey, I was discriminated against. I was retaliated against. The reason I'm having problems with performance is because of my medical condition. If at that point there is not an investigation that is started immediately in days, folks, and you terminate somebody, and then later, because you are being sued, you find out that, hey, by the way, not only did that manager know, but 5 others knew that they had a potential problem because they've been complaining about it, but they just blew it off because they're a complainer anyway. You can see how that can lead to a lawsuit. So it's extremely important that we have a methodology for supervisors to understand during counseling and performance management procedures if a complaint is made at any time or during the offboarding process. If a complaint is made about harassment, discrimination, retaliation, hostile work environment, that we stop everything. Well, we don't stop everything. We finish the current performance management process, but let the employee know, hey, this is important. We're going to be investigating this, and I'm taking you to HR as soon as we finish this process. They may delay the suspension that I'm about to give you or the termination pending the investigation, but I can't tell you that for sure because I need to get you to HR, but we're finishing this meeting. There is a whole detailed process to that, but we do not ignore. Integration. Your policies must be consistent. One leaves concurrently where applicable, FMLA, workers' comp, personal pregnancy, etc. And the application in the ADA needs to be consistent, and the job description needs to have the essential functions. The physical abilities assessment at hire, do it for one, do it for all. If you're going to do it for a job that you hire them for, if you transfer to them to that job, you can require the physical ability assessment, even if it's an accommodation under the ADA. Make sure that you are concurrently designating your leaves. If it's FEMLA because it's leave, but they need accommodation also, you're designating both folks. FEMLA will never take care of ADA under any circumstances. They are separate departments that you are sued under. One is Department of Labor, the other one's the EEOC. They are separate lawsuits. FEMLA never takes care of ADA, everybody. Implementation of the performance management system is to determine and identify accommodation that are failures, not to terminate. Timely notification of potential loss of any benefit. You know that that's my strategy in communication. Let's make sure they know. The failure to do so, I believe, is one of the primary areas of litigation because people are getting their wages cut off or they're losing their jobs and they didn't even know it was going to happen. They did have a clear understanding of what they needed to do to keep it. Clear notification of intent to terminate if they're not compliant. If you do not provide me the medical certificate within 7 days, I will be applying our attendance and leave policies. And then when they don't, you are being considered not eligible for FEMLA, not eligible for ADA. So your job is therefore not protected under either of these regulations, nor is it protected under the other policies and procedures we have or any other state regulation. So if you do not provide me this medical certificate within 3 days, we will be applying our attendance policies. Big black line, and in 3 days, you're just doing your regular attendance policy of an AWOL RIF or AWOL termination. But please notice the strategy of that big black line. You are denying eligibility for FEMLA and ADA first before you are applying anything. And you're making sure that you did your due diligence with undue hardship analysis, with qualified individual disability analysis, with they had an opportunity to come back and you gave them the letter and they saw the letter. It's confirmed delivery and you can know that they got the letter and they still didn't reply to your request for a medical certificate. That's called not acting in good faith. But please have a record that they walked away, not a record of 3 letters that were sent, but you never sent them certified, so you're not sure if they got them and all. Communication is the key. Always provide a good, comprehensive, essential function job analysis. Always make sure employees are aware of the consequences of not providing requested documentation. Make sure the employees know how to report intermittent leave. Do they know how to call your helpline or call your sick line and say, I'm gone today because of FEMLA? Or do they simply say I'm sick and somebody is applying it towards FEMLA because they know they've been on a FEMLA leave? Not okay, folks. Unless you've got something in writing that says from this date to this date is FEMLA leave, you're not protected. If you have something that says from this date to this date, ongoing as needed intermittent leave, every time they request that leave, you need to confirm they are saying it's for a FEMLA protected leave. That is different than us assuming it is. So even though they've got a certificate that says I'm taking Tuesdays and Thursdays off at 2 o'clock, every time they call in on Thursday, if it is a reduced work schedule leave and it's solid and it never changes, we don't have to get that. But if it's Thursday at 3 or Friday at 2 that they call in and they say that's for FEMLA, that's not compliant with the medical certificate first. So I need to document that it's actually for FEMLA. They need to tell me it's for FEMLA, and I need something new that says it's for FEMLA. So anytime intermittent leave is not defined by days and hours, which would be a reduced work schedule instead, they need to tell you every time they request that leave that it's a FEMLA leave. Be clear when the medical benefits expire and how to pay the copay. First day of the month after the unpaid leave begins, you can cut off your healthcare benefits, folks, unless there is a contract with your healthcare provider that says you're keeping them. I never do that under FEMLA, but I sure do as soon as FEMLA's over, unless I've got a policy that protects it, because that alone will get your employee to come back to work. It's a very well-known strategy in workers' comp to cut off benefits. So you can't tell FEMLA is over, or one of your other company policies or contracts prevent it is over. Conditionally designate FEMLA or ADA pending any medical certificate. As soon as you know or should have known at any time that they are potentially qualifying under this regulation, you have a duty to send them an eligibility notice. For FEMLA, you got 5 days. You don't designate or eligibility notice in 5 days. You don't retroactively designate when you get around to sending it. So if it takes you 2 weeks to send it, I am not recommending you say it started 2 weeks ago. Start today, you send it, folks, because you didn't get it out on time. You've already violated the regulation. So let's not continue that violation. Employee has the right to designate FEMLA without the employee's agreement. Did you know that? The employee doesn't have to say, I want FEMLA. As soon as you know or should have known it's a qualifying event, you must designate eligibility. If they don't have a medical certificate supporting, you can temporarily designate and give them 15 days. That's your eligibility notice. But send it out. Don't wait for more information. By the way, this applies to supervisors and team leaders. As soon as a team leader knows or should have known, you know or should have known, even if they don't tell you. So if they don't tell you for 3 weeks, it's 5 days from 3 weeks ago that you could have sent that letter and you didn't. So that means it starts today, not 3 weeks ago. Be really careful about that, because retroactive designation says if you don't harm the employee. I don't know how you cannot harm an employee if you wait 3 weeks and then cut off and retroactively designate and cut off their healthcare benefits as soon as FEMLA is over, and you did it 3 weeks early, and you don't have a document saying that you designated sent an eligibility notice within 5 days of knowing. You sent it after 3 weeks of knowing and retroactively designate. That's going to be a problem. I can tell you most attorneys don't know this yet, but they're going to figure this one out. It's just a matter of time. So medical certificates. Second and final notifications if they're not providing you the certificate or the certificate is not clear. If the certificate is not clear, you are curing, folks. And this is an FMLA regulation. They get 7 days to cure a certificate that's not clear, or they are exceeding, or they have a neurologist signing something about a foot and you don't see the connection and you want more clarity, or it is a foot doctor talking about their back. That might be a connection, but maybe it's not, or a general practitioner talking about a psychological issue. I'd be curing that one potentially. but it does depend on the state you're in. In some states, you can't even ask those questions, specifically in California. If it's yes, and the doctor makes the decision. So you're only curing if they are misusing the certificate. They are exceeding the leave that's identified on the certificate. You can choose to cure that. If you are choosing to cure under FEMLA, you are required by regulation to document why. You need to justify your curing with objective data, have it in the file. You don't need to show it to the employee, but then you're sending a curing notice. And again, these are the kinds of things that we have available on our membership site. So we've got all the curing notice and processes and second and third notices and procedures for both FEMLA and ADA on our website. And that's the reason it's on there, so you know how to do this. Okay, let me add this back to there. So once you post 7 days, a company representative by regulation can speak to the healthcare provider. Why would you be doing that? Well, you could be doing it to say, hey, we're not getting this cured, but I would never, ever do that unless I've got a HIPAA signed form, ever. I'm always going to make the employee solely responsible at all times to provide that medical certificate. I will not be doctor shopping at any time and have to tell the doctor I need them to cure the certificate. The employee must do it. Never signed, no signed info, no info. They don't ever provide you that medical certificate, even though you've asked them for it under FEMLA. You get to deny it. But when FEMLA ends, ADA begins, so you're sending another certificate and saying, gee, we're denying you FEMLA because you never provided us a certificate. Now we're going to transition you to ADA and conditionally designate you under ADA, because ADA is different than FEMLA. And if you're not protected under FEMLA, we're going to protect you under ADA. And this is a different set. And we're sending 2 or 3 letters with or without workers' comp protection under ADA to say, hey, listen, you've conditionally exhausted your FEMLA, so we're conditionally designating ADA for the next 2 weeks because they're 14th and 15th week. Or you are not responding to our medical certificate and you never provided me a FEMLA certificate, so I'm denying you FEMLA, but I'm going to conditionally designate you under the ADA. Very important transition, guys. And it's very different under FEMLA than it is under ADA. And when we send an ADA medical certificate, we want to know what's the disability. We want to know how it impacts their ability to perform the functions of their job exactly. And do they need to walk away, or can they perform any functions? And is it going to cause them any harm if we even accommodate them? That's very different than FEMLA, folks. When we send a request for ADA and we've denied FEMLA for lack of a medical certificate, 95% of the time they then provide the FEMLA certificate because they don't want to fill out our very comprehensive, very detailed FEMLA ADA medical evaluation. When FEMLA ends, ADA begins every time, all the time, no matter what, until you have determined they are not a qualified individual with a disability, which means that even with multiple different accommodations that we've tried, they still can't perform the essential functions, including multiple leaves that keep getting extended, or it is an undue hardship to accommodate them. We can't accommodate telecommuting because it is a confidential, firewalled environment and they can't even get access from home. We can't accommodate telecommuting because their job requires them in-person contact with our clients, or the clients aren't meeting we aren't meeting the contract we have with the client. Those are objective reasons to identify an undue hardship. That's different than not being a qualified individual with a disability. You want to understand the difference, you document it differently. And of course, we've got resources for all of that if you don't understand or you don't have a good procedure for that. We're also going to be developing training by vignette. So we're going to have trainings available by the end of the year for just how do you do an essential function job description and what forms do you need to do that. Just how do you do an undue hardship analysis. We're understanding that that's the level that even if you've got third-party administrators or high-level HR that is available to help, you still need to know how to do that on the ground. Make sure you've got a really good ADA-specific medical certificate. And of course, ours is 5 or 6 pages long, and it's been developed over 25 years simply because we understand what we need and what the doctors need to be told to fill that darn thing out. I always hold a good faith interactive meeting with the employee. If you go to a meeting with an employee with the answers to whether you accommodate them or not, you've already missed the boat. It is you and the employee that are discussing this to determine what you can do and can't do. The supervisor certainly has some valuable information to add, but they are not at the meeting. And heaven, folks, don't let them be the one to decide whether it's an undue hardship or not. They're not at this workshop. They don't understand the regulation. They don't understand what it even means to be an undue hardship. It is a very, very specific and detailed analysis. It is not, no, I don't think I can do that. And that's what causes lawsuits. It's an objective, thoughtful evaluation by function, by disability restriction, because I've looked at ONET and I've looked at the Job Accommodation Network to see if there's any way I could do it. And I brought in a vocational expert, and I brought in an ergonomic expert, and I brought in an HR expert, like somebody like me who has the understanding of these kinds of details. And they couldn't find anything with us when we met with the employee either. And the employee met with us 3 times, and we tried and tried and tried. And that's when we determined that we couldn't accommodate them under their regular job because it was an undue hardship, or they can't meet the expectations of the job with the accommodation, so they're not a qualified individual with a disability. Then we looked at every other job in the country that we met the minimum expectations for, and they couldn't accommodate. Now it's not an undue hardship, and now they're not a qualified individual with a disability because we did all of that. And by the way, we documented it, and we had them sign what we said to them, and it was pristine. Now I can terminate. So really, really be careful, because what I just described to you folks in a nutshell is what our job is and what we're trying to accommodate and get done under FEMLA and ADA before we terminate. And please be the expert in your organization. Remember, supervisors should never be at this meeting because they can't be involved in anything that includes discussions about confidential medical information. And I guarantee you the employee is going to bring it up. The next thing is make sure that you are in charge of the process and you are the expert in the room. So if an attorney at your organization who happens to be a contract attorney and not an employment law attorney says it's okay to terminate, you may just know more than they do about this. So be careful and make sure you're getting some feedback from the right people to get your help. When FMLA ends, ADA begins, do not make a decision without the employee's participation. If you get a worker comp certificate that says 100% disabled, by the way, that doesn't mean anything under ADA because that just means disabled for their job without accommodations. You got to go and engage in the interactive process and ferret out why it's 100%. And did the employee really talk about the essential functions and how they get done and accommodations that you've talked about? Oh, they haven't? Well, let's please go do that first. And then did we look at every other job? And did you talk to the doctor about that and send all the doctor, give the employee all the job descriptions so they could give them to the doctor so the doctor to say they're 100% disabled on every job you have in the country that they meet the minimum qualifications for? That's the job, folks. Take detailed notes and have them sign before they leave the meeting. When I do a good faith interactive meeting, that employee does not walk out the door till they've signed the meeting notes. I proof them, I reread them, I answer all the questions, just like performance management process, but they don't walk out without signing. If they refuse to sign, they don't walk out without initially they refusing to sign. If they refuse to do both, they don't walk out till I bring a third party in and I say, please witness their refusal to sign and have them sign the refuse to sign. Most importantly, I got the time frame that meeting last, and if it lasted less than 5 minutes, I know I didn't do my job. It's going to be 2 or 3 hours if they're refusing to sign, because I'm going to have that employee sit there while I reread the notes 2 or 3 times to make sure there's nothing they don't understand about what I said, even though they're refusing to sign. So I can put a note on there that I read it to them, and they said they didn't have any corrections, but they're still refusing to sign. Boy, is that powerful stuff. Keep in contact and keep detailed records. Never send an email that is not followed up by a letter, folks. You don't know who's getting that email, and send that letter, confirmed delivery and certified delivery, or FedEx if you need to. Use the 3-step method determination if the employee is not acting in good faith. And my method is for FEMLA and ADA is 15 days, 7, and 3. I will not terminate somebody after a third-party administrator says to terminate because they didn't respond to FEMLA. They are being engaged in the interactive process, and I'm transitioning to ADA. They've got to not act in good faith 3 more times for me to terminate them under ADA. And then I'm terminating them because they did not comply. I am not providing them leave under FEMLA, and I'm not permitting them leave under ADA, or maybe I did leave under FEMLA but not ADA because they didn't comply. And then I am letting them know they're not eligible for either leave, and I'll be applying my attendance policies, big black line. Now I'm terminating under my attendance policy the way I would anybody else, but I'm trying to make that clear definer that I'm not terminating you because of your leave or your accommodation or this. I'm terminating you because you didn't comply with our leave and absenteeism policy. I've already denied FEMLA and ADA because you didn't comply with the regulations that we have in our policy that says you got 15 days. And I sent you a letter for ADA giving you 15 more. And then I gave you 3 more. And then you still didn't comply. That's a pretty step-by-step process, folks. I've been doing it for 25 years. It works really well. And all the documentation that I'm showing you on this website literally is the documentation that I've created over the last 25 years, my intellectual property of how to implement all of these steps of FEMLA and all of these steps from the transition and how to deal with pregnancy and how to deal with create essential function job descriptions, amend them, and how to deal with the interactive process. That's what we've got available for you if you're interested in getting that level of support. Okay, let me get this back to here. So in terms of termination, you don't be afraid to use the F word. If they're about to be terminated, let them know they're about to be terminated. Don't say may, please, say will. You got 3 days to come back to work or give me a medical certificate justifying your reason for being gone. Remember, you've already sent the letter denying FEMLA and ADA, so you're not even talking about that. You're saying you got 3 days. And then at that point, if you don't, we're applying the attendance policy. That would be what a RIF would look, an AWOL letter would look like, something to that effect. So make sure that you're applying that AWOL letter. You're not doing that during an ADA discussion. You're letting them know during an ADA process when they haven't provided a certificate, hey, this is the 3rd time you've extended your leave. We're not going to be able to keep extending your leave if you can't give us a real return to work date. If you give us an extension one more time and you don't really come back to work, we'll assume that you're not a qualified individual with a disability because your leave return work date isn't real. That's what we need to know and explain to the employee. Inform the employee when the medical certificate expires 15 days before it, or put in your letter that it's got to be given to you on a certain date. Return to work dates, know them, have them on your calendar. You're calling the employee to verify they're not coming to work, back to work, not the other way around. And please don't ever have the manager have to call you to tell them they didn't show up. That's them doing your job. How to call in or document intermittent leave usage. How do you make them do it? If they call in, they have to say it's for FEMLA, they have to say it's for ADA, they can't just say I'm taking leave today. Concurrent use of or transition from one leave to another, including FEMLA, workers' comp, ADA, your company policies, your union or school policies. Run these leaves concurrently if you can, is my recommendation. But if they don't, or they've got some different format, follow your policies exactly and make sure you explain to your employee how they can get protection. When FMLA ends, ADA begins, transition every time, all the time, no matter what, so you determine they're an inactive, they are not a qualified individual, or it's an undue hardship. When FMLA and ADA no longer apply with workers' comp, use your inactive status designation. In other words, if I've denied or they exhausted FEMLA, if I've denied or I've made an undue hardship with a non-qualified individual under ADA, they're just simply protected under workers' comp, folks, if you've got a state that protects them. If you have a state that requires you to not fire them when they're protected under workers' comp, then keep them on inactive status. But inactive status means they are not earning seniority, they don't get any benefits, they don't get anything. They just happen to be on your books till that workers' comp claim is over. They are not protected under FMLA because you've exhausted it, they didn't comply. They are not protected under ADA because they didn't comply or they're not qualified individual. Those are strategies. As soon as FMLA ends and an ADA accommodation is needed, including leave, you temporarily designate that accommodation as ADA. And when FMLA ends, ADA ends and the ADA accommodation is an undue hardship, or they're not a qualified individual with a disability, make sure you schedule a new meeting to discuss the end of that current accommodation because it's not working, and determine if there's any other accommodation you guys can come up with. And if it's not working because they're not providing the medical certificate or they keep extending, well, you got to let them know that and document it in writing and make them sign that they know if they keep extending that medical certificate, that's going to be considered an undue hardship. Really inform. If the employee does not have a workers' comp claim, you may terminate the employee at this stage. So once it's an undue hardship or they're not a qualified individual with a disability and you've determined there is no other job in the country they meet the minimum qualifications for that you could accommodate them under with them, that's your termination stage. If the employee is also workers' comp, then you're putting them in inactive status. Communication is key before it happens, folks. You want to communicate before leave ends, before vacation ends. before their paycheck will stop, before you need a certified new medical certificate, and let them know the date they've got to get you attention. I put on my calendar at least a week before those things are going to happen to make sure I send them a letter saying, your healthcare benefits are ending next week. This will be an unpaid leave. And if you've got a state protection or STD or LTD they should be applying for at that point, make sure you understand that and inform them. If COBRA is going to be implemented because FMLA is ended and ADA doesn't protect their medical benefits, make sure that happens, but always communicate it before it happens and hold them responsible for complying, because they're going to hold you responsible for when the money stops and when they get terminated. You'll be named on that lawsuit, folks. Never want to place an employee in a position of having their leave become unpaid, losing medical benefits, or losing an return to work opportunity because you got a certificate that you don't think makes them qualified without communicating with them. That's called the interactive process. And we want to do it in writing, in person, confirmed delivery, signed meeting notes. Consistently apply all your regulations. Any policy that says you have to provide a return to work release means all policies must say you must provide a return to work release. And it's usually based on time off work. If it's administratively you are not applying it to people who have gone less than a week and your policy says all, change your policy. We usually see organizations say after 1 or 2 weeks, we're going to require you to do that. So make sure you're clear. And whatever you decide, that all the policies say the same thing and all the policies require it. Verify the company letters of request for information are consistent for all types of leaves, where they apply. And of course, there are different criteria for all leaves. And that would be why on our webpage, we have a different designation letter for FEMLA and a different curing process and a different designation for ADA and a different designation letter for the transition for FMLA. And all three of these letters are different when it's workers' comp. So these are the things that are very important to understand when you are creating your own slide set if you don't want to use something like ours that is pre-created for you. Apply the time frames for providing and clarifying medical certificates. We use the 7-7-day rule for both FEMLA and ADA, by the way, and it's very, very effective. Most of you do not do second and third opinions. We've been doing it for 25 years, and oh man, are they effective. They're the most effective thing you do. So if you are one of the 99.95999.9595% of the employers who don't do this, call me. It's effective. And we do it when they are violating the certificate, or they've exhausted FEMLA and ADA and they can't get a medical certificate from the doctor, and the doctor is the problem. So there's lots of reasons you'll be doing second and third opinions, but they are really effective for stopping abuse, by the way. Apply the time frames for the certificates. What is your time frame? 15 for FEMLA. What about for ADA? Do you just let them give it to you when they get around to it? Let's create a system that has time frames. Require constant rules for reporting FEMLA and ADA and apply them across the board consistently. If you doctor call for one, you doctor call for all. Application of performance management consistently for all employees, no special consideration unless a documented part of the reasonable accommodation process, which means if they can't perform the essential functions of the job with the accommodation, we're documenting why, but then we're going right back to the interactive process. But if we've tried and tried and tried and they still can't meet the expectations, they need to know they're about to lose their job because they still are not producing enough documents using drag and dictate. They're not producing enough materials using the new equipment we gave them for lifting. All of that is a rationale for termination if you've exhausted all jobs that meet the minimum expectations and they still can't be accommodated, or you've exhausted multiple leaves and they're still extending. But don't be afraid to use the F word, folks. If you're about to fire them the next time, tell them, don't say maybe, say you will be. When you say you will be, you'll be surprised at how often they will change the way that they interact with you. For an essential function job analysis, go to O*NET. You will find everything you need to build it on there. We do a lot of training on this. We're doing a training in September, the first week, I think the 9th and 10th, and we're doing a training that's in San Jose, and we're doing a training in San Diego the first week of October. Those are the ends of our training for 2017. So if you need help with training, especially if you have people in California, this is a day-and-a-half training that teaches you all the nuances of how to implement what we've talked about. But a job description should minimally include skills, abilities, qualifications, training, educational requirements, job functions, major job functions, and the machine tools and work aids and the special clothing and protective devices you use to perform that job. Without that information on there, how do they know if they can perform the essential functions, folks? They can't. ONET really shows you how to do all this. There's a trick to it beyond that, but certainly that gives you the basic information you need to amend and supplement your job descriptions. Then you apply the performance management and standards and see if they can actually perform the job with the accommodation. The performance management system needs to be objective, consistent, and provide useful, valid feedback. That means it needs to objectively identify why they're not meeting the essential functions. It can't just be the manager's opinion. You need in writing from the manager exactly what the problem is, especially if they're telecommuting. Always implement your informal or formal progressive disciplinary procedure, but you're applying it from the perspective of inability to meet essential function with accommodation. And then when they can't meet that, you're saying, is there anything else that I should know about that's impacting your ability to perform the functions of your job? Well, yeah, it's just not the accommodation. All my coworkers are harassing me and I just can't stay at work and because I'm so embarrassed. Or the supervisor is making me do more or putting pressure on me because they're mad I'm not getting it done enough and I'm having to still train. Boy, those are big issues, aren't they? If that's the reason the employee's having a hard time meeting the job functions, you're going to have to implement an investigation to see if that's true before you even remotely consider removing that accommodation. Because we don't know if it's the behavior of the employees and the supervisor or the accommodation itself. Extremely important stuff. But remember, it is the process of discussing the ability to perform that brought that issue up, that sent you to an investigation. So don't let supervisors or managers create counseling forms or write-ups with people who are in protected leave or accommodation without you looking at it very, very carefully. So you're sure that they are meeting the expectations of this job and they're doing it right. And it's not something else that is a problem that the supervisor is not recognizing, or that the supervisor doesn't do a write-up saying they're not attending the team meetings in an effective manner and therefore are not a good member of the team. And the reason they couldn't attend the team meetings is because they were on a protected FEMLA or ADA leave. You can see how that would be a problem immediately. Consider waiting until they return to work to impose any performance management processes that included termination or suspension if that was happening before they informed you of the need for leave. Be careful and be willing to tell them they'll be fired if they're still behaving in a way that violates a completely different company policy. Don't terminate for cause unless it is very clearly not related to a condition of disability or protected class. And that means an unbiased person should be looking at that before you terminate, especially if it's coming from a third-party administrator or a supervisor's recommendation. Then you rescind all counseling, suspensions, or terminations if you determine something got missed. What if the supervisor did miss the fact that they asked for leave for their stress and then said they couldn't accommodate them because they were not meeting expectations, but in fact, they said they needed an accommodation under stress and they never addressed it. Those are the kinds of things that get missed often, and we find out during a full-blown investigation, and then we would rescind potential counseling. Always err on the side of the employee. If they are a poor employee, they will give you so many chances to terminate them later. Don't do it now if the supervisor missed something. And act in good faith and show you acted in good faith. A performance evaluation or counseling is a formal discussion to clarify, define, and guide. Make sure you are always, in fact, asking them if anything else is impacting them, because that will be your key to identifying if the supervisor did something that you don't know about. Develop that joint plan of action, whether it's for managing performance with an accommodation or dealing with an issue of conflict due to personality that they are blaming on hostile work environment or harassment. You're not going to know what the real issue is until you investigate if they complain about that kind of issue. But if the supervisor says there's a problem with performance, you've got to evaluate process of compliance with the performance process with the accommodation to see what the problem is so you can fix the accommodation. You're not doing it to determine termination. You're doing it to determine accommodation success. Very different process. Always let the employee take ownership of what they did and what they did not do. So you can apply the policies and they take responsibility if they're supposed to be there on time. That has nothing to do with the accommodation. They get there on time, so they know they're terminated because they're not getting there on time. Has nothing to do with their drag and dictate accommodation. Always the same process, everybody. The reason that we've got a web page with resources on it is because we want you to do it the same way every time, even though the meeting itself may sound differently, may last longer, may take more effort with every employee. The process should stay the same. So same method of analysis, same method of documentation, same method of meeting format for FEMLA, ADA, workers' comp, pregnancy disability, and related accommodation and FMLA opportunities. Inform, 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 document, document, document. That's what's going to prevent litigation and reduce your stress, because you'll have something ready to go. You won't have an emergency situation you have to respond to. You'll know they were supposed to come back and they didn't come back 2 days before they did. Follow the bouncing ball. As soon as you drop those dates, you're no longer in control. The employee is, and you're relying on the manager to tell you what's going on. Proactively reach out to employees when they have an accommodation or pregnancy or workers' comp or ADA light duty issues. Make sure it's working. I check every week with the supervisor and the employee to make sure that accommodation is working separately. If it's working, I'll check with them a week for a month. If it's working, I'll check with them one more time for 2 more months and document it, and then I'm done. So 4 months later, they say, well, it's got nothing to do with my job performance. The accommodation isn't working, and I've got a month of documenting. Everybody said it was. They've got a problem, and these are the reasons we do it. We know your employees are your most valuable asset. Let's just make sure that we help them understand the expectations. They're not walking in with these meetings and these requests with an expectation that they're fully protected no matter what. They aren't fully protected if they cannot perform the essential functions. And they are not fully protected under FEMLA and other state and federal regulations if they are not meeting the criteria of the medical certificate. So good documentation is what protects you. Comply, integrate, communicate, follow up, and do this consistently. This is the information about the workshops that we've got going on. That's September in San Jose and October in San Diego. And this is information about what we do. But I'd like to open it now. Does anybody have any questions or comments? Because I'm looking at the chat window right now. If you do, please feel free to chat me if you've got any. And they said, do you have recommendations for tracking all the follow-up dates? And I do. The recommendation that I have for tracking the follow-up dates is to make sure you calendar it. I have a separate Outlook calendar that is just for the dates. Every Tuesday, I do my meetings for Good Faith Interactive, FMLA, or any other leave-related or accommodation-related meeting. Every Thursday, I send out the letters for the things that are happening the week before, or I am making calls, sending emails, and following up with certified letters if I know that they're supposed to come back and they haven't told me they're not going to, and I expect them to come back next week. These are the things that we calendar. Having said that, we are trying to get something created for you that will be a free part of our website, by the way, by the end of this year. But in the meantime, remember, the dates matter to them, so they should matter to you. So make sure the real date is on your calendar, but then I put the actual cumulative activities on 2 different days, Tuesdays and Thursdays. And if there's enough leave, it could be Monday, Tuesday, Wednesday, and Thursday, Friday. I'm dealing with this every day for half a day. And then I'm closing my door and not answering my phone and putting a sign that says no appointment scheduled during this time, so I can effectively manage my leaves. You can see that we've got meetings that happen twice a month on the 2nd and 4th Wednesday of every month at 10 o'clock Pacific time. You are welcome to attend those meetings for a minimal charge. We open it to the public because you can get Sherman HRIC credits if you attend. If you're a member of the web page, you actually get up to 24 credits a year, and they can be California specific that are SHRM and HRAC qualifying just by attending our meetings. We also have letters, forms, we have the medical certificates for FEMLA and CFRA, we've got the transition letters, we got the caring letters, we have third request letters, and second and third opinion letters. That's all the stuff that I showed you on the web page. If you're interested in getting information about any of that, it basically is under the criteria of, or under the web page of leave management solutions. And leave management solutions then is a landing page that can then take you to, let me see if I can go about, it can take you to the training programs, but it also takes you to a place for you to schedule a demo if you want to see what the demo is, or actually go to the membership area, and the membership area takes you right to the icons that I was just showing you here and shows you the different resources that we have. And you'll notice not only do we have letters for you, but we also have training videos depending on state or federal. And the first section of this is just all the training charts that we and flow charts and checklists that we have to help you learn how to deal with that transition from FMLA to EA. And then we've got all the letters you need to transition, and with or without workers' comp. So thank you, everybody, very much for joining us. We really appreciated you participating today. Please let me know if there's any questions that you had that I didn't answer. You can just email me. And of course, if you are interested in getting more information about our webpage, please feel free to just give me a call or contact us through the webpage directly. And then think about coming to one of our trainings or coming to the training that we're doing live. We're going to be doing trainings nationally, hopefully in Chicago and maybe Texas, maybe New York next year. But right now we've been focused in California because California is where people get so frustrated, especially if they're national organizations that have California specific needs. In addition to that, we do this training on site. If you email me and you're interested in coming to one of the meetings where we literally do scenarios for an hour with everybody who's on the meeting and answer questions about how to apply these strategies, send me a text email or to send or text me and I'll get you a coupon to get you onto that meeting for $9. It's usually $75. It's free with being a member. So again, thank you very much, everybody. It was a pleasure to speak with you. We'd love to get feedback, so feel free to email me. If you email me and let me know what's going on or what you thought about it, I'll be happy to also send you a slide set. Just email me and let me know you need it. Thanks, everyone. Have a great rest of the day. Bye.